Bill Henshaw here again with a question asked from a viewer, which is the kind of thing I love. And the question is, are state bar associations constitutional or not? There's not a pat answer to that question per se, but I would think that they could be if their activities were limited to the proper subjects of influence of state legislatures. And when I say state legislatures, I say that with quotation marks. There are no states. But if they were limited to that, and for those of you that don't know, if you're a person within the meaning of the 14th War Amendment, you're an artificial corporate entity, and you're subject to statutory schemes enacted in Sackler Tomato, for example. In that context, I think no question about it, because there's got to be a way for corporations, to deal with the system that they're in, even though the legislature is their creator, they still have some privileges that they can exercise from time to time. But for you and I, the average Joe six packs on the street, otherwise known as members of the sovereign body politic of the nation and republic, and or the beneficiaries of the trust known as the United States, no. And it's so bad that what's seemingly applicable case law today, which if you get my document packets and send me information for that, send me an email at uncourt@gmail.com, and you find out that the use of an attorney who is, after all, an agent of the court is a stipulation to the jurisdiction of the trial court to get jurisdiction it could get in no other way, an officer of the court. So we know immediately we can't use it. The beauty of this is my recent epiphany on the council issue. I've got to mention this one while I'm here. I have, but I want to reiterate the point here. Is we go into their courts, traffic court, whatever, and with my documents, by the way, you hit them up front, hit them in the head with documents before you get to the arraignment. That's even better if we can do that. If you get to me too late, that's also okay. It works almost as well. But you get there, and now you're going to have close to 200 pages of legal documents in there, which they can't dismiss as your interpretation of the law. I can't tell you how often I've heard that, especially recently in the Oakland case. But the deal here is that if we use one of their attorneys, we stipulate to the jurisdiction, but at one and the same time, we have the right to effective assistance of counsel, which does not emanate from Section 1 of the non-existent 14th War Amendment. We have rights secured by all 6 articles of the Constitution, and we have a hope in hell of being able to go into one of their quote-unquote courts and being able to invoke those rights, especially since we're not taught a damn thing in the mandatory public quote-unquote education system. The first 12 years you're in school. Not a damn thing. I wasn't taught 50 odd years ago. You're not being taught today, and neither are your kids. Accordingly, we need counsel, and counsel who is fluent in the constitutional issues that we want to put in as affirmative defenses, and we have every right to do that, any one of which defeat the jurisdiction of the trial court and end the case. And you do that one time, they're probably not going to come back on you again. I've done it myself in California. I'm finding it very hard. In fact, I was a bit surprised last year, to be charged with the crime of the century, my jaywalking case. I thought they would know better than that. And the traffic commissar, by the way, got the hell out of the way when I showed up in traffic court. And I think he's one of the good ones that sent the case over across the street to the real court, where I talked to what appeared to be a real judge for like 40 minutes before I got convicted. Wish I had a recording of that. It was an interesting set to for those 40 minutes. But so I got convicted, and at the end of this trial, it says, okay, we're going to fine you this, that, and the other. Came to $95, and I fired off the top of my head. I said, fine. Define dollar within the meaning of Section 6850 of the California Government Code. And oh, by the way, right after that, I said, and that comes directly codified from the Political Code of 1852 with no changes. And at that time, the definition of dollar was the Coinage Act of 1792. A year and a half later, I'm still waiting for a bill for that 95 quote unquote dollars that I'm never going to see because they can't answer the question. That's how good that is. And yet, no attorney in his right mind is going to go in there and make an argument like that. Not if he has any, concerns for the safety and welfare, not only of himself but of his family and maybe his professional standing as well. They're not going to do it. If you find one that would, I'd love to hear about it. The only one I know is Jerome Daly, and we've talked about him on some other tapes. But if you find one like that, let me know. Send in my email address, youwinnincourt@gmail.com. I would love to hear it. But that's the problem. So not only, we can't use the ones that they have, and they're so utterly ignorant because they're not taught in law school even the issues that I advocate and the ones that you're going to learn from getting my documents. And yet we've got every right to challenge jurisdiction from day one and be able to do it. Now, the great news for that is that the Argersinger Doctrine of the 904, the U.S. Supreme Court, Argersinger v. Hamlin, 407 U.S. 25, page 40, and the court says right in there, under the rule we announced today, let every judge know at the start of a misdemeanor trial, let alone felony, that no imprisonment can be imposed though local law permits it when the accused was not represented at trial. Now we get to ask our version of the question, why bother to have a trial at all, since if you get a conviction, we ain't going anywhere. By the way, what does this say about the bastards keeping you in jail, awaiting trial, going through all this pre-trial BS and this, that, and the other, and Barfetta hearings, when they know they can't get a conviction and keep you in jail, and they do it anyway, trying to drag it out as long as possible to try to compel you to accept the plea deal. And this Oakland thing is going to be a huge case in terms of punitive and exemplary damages if we were to get it to a jury for them doing exactly what they've done in this Oakland case. Kid's been in there 6 months, and they knew almost from day one they're not going to go to trial. That's the kind of power that we have. Anyway, getting back to the state bar associations, and in California, by the way, they didn't exist until 1928, for what that may be worth. And very soon afterwards, things started to go downhill sharply here. Not only here, but that, just a stone's throw from FDR getting in with the New Deal and that deck of 52 jokers. And they had a supposedly secret meeting, by the way. If any of you know about this, get back to me. Send me an email at youwinnincourt@gmail.com. Because my internet researches haven't turned up anything, but I wouldn't be surprised if there was, in fact, a secret meeting along about 1937 or 38 about the time that the court issued its decision in the case of Erie Railroad v. Tompkins, and I spell that E-E-R-I-E, that fundamentally changed the course of American history as well, where the judges all got together and some of the more important people and said, this is where we're going to be doing business from now on, and this is what we want everybody to do. I'd love to know about that. If it can be proven with hard evidence, that's a game breaker, is what that is. And I'm going to keep looking on the internet, but I haven't found anything to this point. So yeah, bar associations have a fairly limited place. In earlier times, by the way, you didn't really have bar associations as such, and lawyers would travel around in many states from city to city, lawyers on both sides who were friends, and they would go from city to city and try cases, because you didn't have regular courts or regular sessions for the most part, up through at least the mid-19th century. So it was a much different situation than what we have today. So that was quite common, and that's what Abraham Lincoln did, by the way, for part of the time before he became president. He was on a circuit like that. As for certainly a number of other, eminent people that got jobs in the government later on, too. And that was okay, so there were no bar associations per se, and the attorneys were much more likely to be not only very familiar with the original intent of the Constitution and our rights secured by the Constitution, but to make arguments like that in court cases, especially for you and me, and that's why there's so many more cases like that, what I call vintage cases, than what you see now. All they argue is 14th Amendment case law crap. That's all they want to hear. But that's not the job the attorney has. And we may, if things go well here, it's not going to happen overnight like everything else here, but I win the Oakland case, that could be the beginning of the end for the State Bar Association here. And in fact, I'm headed later this week to the office of the State Bar in San Francisco to hopefully confront the president of that bar association and ask her why she did not respond to my certified mail letter that I sent her, asking her to order her agent as the State Bar Association attorney to do the job that his client, aka principal, wants him to do. I tried that with the local bar association, Alameda County Bar Association. It wasn't a responsible party anywhere in sight. I got a damn piece of paper with a phone number on it. Good luck. See you later. Can't work that way. There's got to be some way to enforce, what you want. I mean, it's our wishes. We're the principal here. We created all this government. We tell them what to do, not the other way around. That's what has to change. Unless or until it does, I personally have no use for bar associations. They can all go to hell. Back with me, given my druthers, I'd like to have one of them a day sitting in the electric chair, and I pull the switch on 2,000 volts every day. Get rid of the bastards. Don't need you people anymore. So that said, they have a very limited, area in which they can act, but there is room for them in the American system of jurisprudence. Just not nearly as much what they mislead you to believe is the case.
And who is that attorney that doesn't want to help your client? What's his name?
Oh, yes, Daryl Stallworth, otherwise known as Daryl Smallworth. Didn't do a damn thing, sat there for 25 minutes, didn't look at any of the documents, said he hadn't had time to look at the documents I sent 2 months ago by email, sent back a certified mail letter that I've got in my hand. I scanned it into my computer, and if we ever get this bastard in front of a jury, it's not going to be pretty. That's why they're going to sit down at the bargaining table and get the water cut, because they can't have that happen with me unfiltered by one of their attorneys. That's where we get the bastards, and that's what I can help you do. You get my documents and set up the case with your case being an unopposed record in the trial court. They can't deal with that if there is any offensive action, even a civil rights claim, which isn't what I do. Because with the unopposed record, either we beat their summary ex parte 12B6 motion to dismiss, or we get right to the 904 on the express train and let them explain to us how we failed to state a claim for relief upon which can be granted. If it can't be done when there's no opposition, what are they telling you? They would have to admit, in effect, there is no Constitution and we have no rights. And by the way, that's the one thing I did hear about Roger Brooke Taney, our greatest justice, let alone Chief Justice, when I was in school. The only thing you heard about Taney was what he said in the infamous Dred Scott case, where he said exactly and verbatim that the black man has no rights that the white man is bound to respect. True. Read the context in which he said it. He was talking about the time around the American Revolution before the Constitution. No one ever tells you that. You read the entirety of the opinion, it's anything but infamous, and yet most of the justices on today's court, and all of them probably throughout the 20th century, referred to that as an infamous case that embarrassed the court. That's not a good qualification for someone sitting up there with the 904 wearing one of those black robes. If that's what you think, that's a serious objection to your even being there. But you have to understand, in fact, that's a case I'll do more seriously on one of my next videos. I will do the Dred Scott case. It's a long case, by the way, even by today's standards, because there were multiple opinions. It takes up 370-odd pages. And if you get there before I do, by the way, you can look it up on online. It's 19 Howard 393. It's a citation. And this is one of those vintage cases, and they weren't all this way. But it comes up, and you'll see that in the official records in the United States Supreme Court reports, not in the lawyer's edition, and certainly not in the U.S. Supreme Court Reporter, the most worthless set of law books I've ever seen. But in the U.S. reports, the official one, they have the arguments of counsel on both sides on the issues that were being presented here. When the court does that, you should take the hint that that's an important case and read those arguments on both sides, not to mention the decisions, all of them, the majority opinion, concurrences, dissents, footnotes, and you'll learn much more from doing that than if you just have a basic familiarity with the case. And that's why I'm so tough to beat, because I do it and I can talk a lot more about those cases than just simply what book and what page number it's on. I know a lot of details about the case and the issues were discussed, much more than what you get in law school. And these attorneys get embarrassed in a hurry because they can't keep up with me. You get my materials and study them, and believe it or not, it won't take you that long to get to that place because these people are so ignorant on the other side, you can't stand it. Maybe a road professor in law school, I don't know. But from what I've seen in my 5 decades in the courtroom, quote unquote, give me a break. This is all we have? Oh, don't get me started on that. In any case, like I said, you love to get the information I have, and be sure to send me an email, uwinnincourt@gmail.com. I also encourage comments, suggestions, and questions about this. And on any video I do, by the way, I also encourage serious opposition. If you have that and can prove me wrong, you just don't send me an email and say that's your interpretation of the law or you're nuts or this, that, and the other. But you do it with authority. I encourage that. I want to see it. If I'm wrong, I want to know it.
Also on YouTube, too, you can comment on YouTube. And then if you want to further discuss it with Bill, just go to uwinnincourt@gmail.com.
Yeah, good. We can do that. And like I said, that's a valuable resource to have. So if I'm wrong, I'm not like most of these attorneys have nothing but an ego and think stupid ass idiot and don't know a thing about it and leave the law to me. I know the law and you're too ignorant to know it. That's how attorneys are. They're stock and trade to do that. And insult you and demean you. That should tell you right away you probably don't want to deal with an individual like that. And you get my materials, you won't have to. You can do it yourself and do it a hell of a lot better than they can. That said, remember to like my videos, subscribe, and tell your friends. Thank you.